The Sixth Amendment to the Constitution provides rights and controls for those who are accused of a crime. Here is how this amendment is written in our Constitution. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. But what do these words mean in real life? Time is the first thing addressed in the Sixth Amendment. The first line calls for the accused person to have a speedy trial. This does not mean that the trial has to be completed quickly. Instead, it means that the accused should not have to wait in jail for a long time for their trial to start. This part of the amendment is often called the Speedy Trial Clause. But how long is too long to have to wait? This question did not get answered until 1972, when the Supreme Court heard the case of Barker versus Wingo. In that case, a defendant had to wait more than 5 years for his trial to start. The Supreme Court said that was too long to wait and suggested that the government had about a year to bring an accused person to trial. After that amount of time, it is reasonable to say that the accused's rights are being violated. The second part of the Sixth Amendment creates rules for how people who are accused of a crime are treated. It is meant to protect those who are innocent. This part of the amendment states that the accused have the right to an impartial or unbiased jury. An impartial jury is made up of people who are going to make their decision about guilt or innocence only after hearing all of the facts in court. One way that this part of the Sixth Amendment is upheld is through the voir dire process. As jurors like me are being chosen for a trial, attorneys for both sides of the case get to ask questions of each potential juror. They want to know that each chosen juror can be completely unbiased. Attorneys ask questions to ensure that each juror either knows nothing at all about the case, or he or she hasn't made up their mind about the case before it has even started. If I am chosen to be on a jury, how many other jurors will there be? Well, that depends on the case. If the accused is accused of a federal crime, there are 12 jurors on a jury. With federal crimes, the jurors must reach a unanimous decision to find the defendant guilty. For non-federal charges, the states each get to determine how many jurors serve on a trial. Some states have as few as 6 jurors. In state court, the decision of the jurors does not have to be unanimous. It can be a simple majority. The Sixth Amendment includes other important rights for the accused. For example, it states that the trial must be held in the area where the crime took place. If it isn't, this might be unfair to the person accused of the crime. The defendant also has the right to know what crime they are accused of committing and who has accused them. The defendant also has the right to ask questions of his accuser. This means that if you are accused of a crime, you have the right to know exactly what criminal charges are being filed against you. This clause was written because under British rule, the government could lock colonists in jail for years without ever telling them what crimes they were accused of committing. The last part of the Sixth Amendment allows the accused to summon, or call to the trial, anyone who might help his case. Even if a witness does not want to come to court, they can be forced to do so. Attorneys can issue a subpoena, which is a written demand that the person appear before the court. If the witness does not go to court, he or she can face charges and fines. The Sixth Amendment also gives the accused the right to an attorney and states that an attorney will be provided if the accused person cannot afford one.